Welcome aboard, applicants. I thought we'd begin with the General Bar Exam February 2020, question number 3. As with all essay questions, let's begin with the call of the question. Number 1, is Sam likely to prevail in his breach of contract lawsuit? Well, right here we know our area of law, breach of contract, tells us that our area of law is contract law. Lawsuit against Barn, and if so, what damages will he likely recover? Discuss. 2, is Barn likely to prevail on his lawsuit seeking what? Specific performance against Sam. Discuss. Okay, now, under our calls here, we want to make sure to pull out Sam v. Barn. Okay, so up here, number 1, is Sam likely to prevail in his breach of contract lawsuit against Barn? Question mark. Sam v. Barn. Number 2, is Barn likely to prevail in its lawsuit seeking specific performance against Sam? Remember, make sure to put down Barn v. Sam. Okay, excellent. Second page there. Oh, no, we're going to be doing a second essay, but I'm going to bring this down just to the third page. Thank you for your patience. Okay, now let's read our question. Question. Barn exports Barn hired Sam, an up-and-coming artist whose work was recently covered in Modern Buildings magazine, to paint a one-of-a-kind artistic design along the border of the ceiling in its newly renovated lobby. After discussing the work, Ed, the president of Barn, and Sam signed a mutually drafted handwritten contract. So I want to make sure to put this in here. Hand drafted the handwritten contract right here, indicating that it's validly formed. Now up here as well, I wanted to bring this to our attention that we have an up-and-coming artist. Okay. Now, and then to paint a one-of-a-kind artistic design, make sure to bring that out. Okay. Now, Sam shall paint a unique design along the entire ceiling border of all public areas of the first floor. Barn shall pay $75,000 upon completion of the work. Okay. When Sam began work, he was surprised that the new plaster ceiling in the lobby had not been sanded and sealed. Sam complained but was told by Ed that preparation was part of his responsibilities. Although Sam disagreed, he spent 4 days sanding and sealing the ceiling. When Sam finished the painting, he submitted a bill for $78,000, having added $3,000 for labor and supplies used in preparing the ceiling. In response, Barnes sent a letter to Sam stating that because he had not painted the borders in the two public restrooms in the lobby, no payment was yet due. Barnes' letter also stated that it had recently spoken to several artists who performed similar work and learned that surface preparation was typically the responsibility of the artist. According to Sam, before the contract was signed, he had told Ed that the restrooms could not be included because his paintings were not suitable for the high humidity in those locations. Now, Sam sued Barn for breach of contract in the amount of $78,000. Barn countersued for specific performance to have the borders in the bathrooms painted. Okay, so let's get started here. What contract in terms of, remember, for number 1, Sam v. Barn. What is our applicable? Well, I'll throw down our shopping list: contract formation, third-party rights, covenants, conditions, excuses, discharge duty to perform. Oops, excuse me. Thank you for your patience. Breach of contract and remedies. Okay. Now, what would be our applicable law here? Well, because we're dealing with what here? Right here, to paint. Painting, which sounds a whole lot like services to me. So let's put down common law and put down services. oh, excuse me, and equal sign painting. Okay. Now, after that, we want to make sure to do contract formation. Remember though, we have, what is it we have in terms of our validly formed contract? That's that mutually drafted handwritten contract. Okay, good. In terms of the mutual assent, did we have the sufficient quantity, time, interested parties, price, and subject matters? Let's take a look here. Well, we know that the barn contract, let's see here, excuse me, that the Sam v. Barn situation initially involved the $75,000 upon completion. So we know that the original contract price was for $75,000, and so I want to make sure to note that. And also, it was the details indicated that the unique design was supposed to go along the entire ceiling border of all public areas on the first floor. So, okay, so there we go. Okay, so make sure, yeah. So down here, we want to make sure to point out that $75,000 was the original contract price. Okay. Now, and that there was consideration talked about, and then we also make sure to throw in a small discussion of statute of frauds, which is satisfied. Okay. How do we know? Because it was in writing. Okay. Now, down here underneath, basically the performance section of our contract, what happens now after this point here, that when Sam began work. Now, also too, I want to make sure to point out that our type of contract here is a unilateral contract. Okay. Means that the acceptance upon completion of the work, because the situation was such that the 75,000 was upon completion. So I want to make sure to point that out, because that'll also be helpful for conditions aspect. Okay, now when Sam began work, he was surprised that the new plaster ceiling in the lobby had not been sanded and sealed. So Sam complained, but was told by Ed, remember who Ed is? Ed is our president of a barn, that preparation was part of the responsibilities. Although Sam disagreed, he spent 4 days sanding and sealing the ceiling. So we want to make sure that we throw down modification at this point. And what type? Remember, we're dealing with a common law modification. And in terms of common law modification, we talk about mutual assent, and we talk about consideration. Remember, in this type of situation, we want to make sure that new consideration at that. Okay. And what was the new consideration? Well, Sam had to pay $3,000 more for labor and supplies for preparing the ceiling. The argument could be made, well, was this a valid modification, between the parties? Well, it could be argued as such. Why? Because, well, under Sam's perspective, he's going to say that the $3,000 was sufficient new consideration. However, Barnes going to say what? He's going to say, no, this is for the exact same contract. You're having to foot the $3,000, which is actually part of the performance itself. And maybe the party should have agreed to that at the time of contract formation. So the sticking point here is whether we have sufficient consideration. That's the discussable point. And then also too, we want to make sure to bring up the parole evidence rule. Okay, and primarily here we're going to be having Barn, who's going to say that the four corners approach, which I'll put that down here, is going to limit the contract to what? To the aspect about what is involved in this particular term, public areas. Okay, because right here, surface. If I remember correctly, in our question here, right here, in response, Barnes sent a letter to Sam stating that because he had not painted the borders in the two public restrooms, no payment was not yet due. Now, Barnes' letters also stated that it had recently spoken to several artists who performed similar work and that learned that surface preparation was typically the responsibility of the artists. Now, so what we're looking at here also too is what is the term dispute here between the parties? Because up here, Sam began work, surprised that the new plaster ceiling in the lobby had not been sanded and sealed. Sam complained, but was told by Ed that preparation was part of his responsibilities. Although Sam disagreed, he spent 4 days sanding and sealing. Remember, what is it that they meant up here by public areas? Where am I pointing to here? Okay, on all public areas, right? So we got the terms that are going to be disputed here are going to deal with what was it that represented public areas, and what was it that was surface preparation. Okay, and we're going to be able to bring in things like gap fillers, and or I should say this, reasonable terms like the customs of the industry, which looks like what Barnes sent back. But remember here, what is it? What is it that even if we're dealing with, and this is what we're talking about here, is an interpretation of the terms. Okay, so I want to make sure to pull that forward just a little bit here. Even with this taken into consideration, what is it that Sam is going to say? Well, he's going to say that these what concerning the fact that the lobby had not been sanded. He's going to say, well, was this typically the responsibility of the artist? Well, he's going to say no, because he's going to say that the $3,000 should be part of the contract that was what, based on painting the entire ceiling of all public areas. So that would be his concerning the first floor lobby. Now, after having said this, we want to also make sure that there is an exception to what would otherwise be a fully integrated agreement, and that the exception may involve this aspect: proving up what would be a condition precedent. I'm going to possibly throw that in here, but we want to make sure to put this down here as well, that a condition precedent was what the facts were indicating when Barn responded up here. Upon completion, that was also an indication to us, and that right here in response, Barn sent a letter to Sam stating that because he had not painted the borders in the 2 public restrooms in the lobby, no payment was yet due at this point right here. And so that's what Barnes is going to say, that the part of the payment from Barn had not been satisfied by Sam, because Sam had not painted what the entire what would be the entire public area, which would according to Barn include the public restrooms in the lobby. So with that, then we keep rolling here. We come down and we talk about, first we're talking about the anticipatory repudiation. Also, we can kick out at this point. There's no third party rights. We've already talked about contract formation. We've pretty much hit upon the conditions, and right now we're talking about whether or not there were any type of excuses. So, but I think at this point, what Sam is going to see that Barnes' letter right here. Barnes sent a letter to Sam saying that he had not painted. Sam may see this as an anticipatory repudiation on the part of Barnes. Now, the argument here then is Sam likely to prevail in a breach of contract suit against Barnes? So let's continue to argue this. Breach of contract. And remember, dealing with common law, we need to establish substantial performance. And remember, okay, now, all right. Okay, make sure we're going to talk too about remedies here. underneath remedies, we want to make sure that in the event that what because in the event that that Sam has conferred to Barn a benefit, and has Sam conferred to Barn a benefit? Well, let's take a look here. Beginning work, we know that he began work. So where okay that so there is some form of a benefit. Now, let's see here. According to Sam, before the contract, he told we're not suitable for high. Sam. So basically, we're looking here. It it pretty much indicates to me that Sam has conferred to Barn a benefit in some form concerning the painting. Okay, the painting of the or what was the painting of the entire public area, including the lobby. Okay, and including that $3,000 for labor and supplies. Okay, so down here, we want to make sure to bring that to the forefront that we're talking about compensatory damages, okay, which would expectation damages. And we're also going to be talking about, was there any reliance damages? I don't think so, so we'll click that off. Any consequential damages? That may not be foreseen at the time of contract formation, so no. How about any incidentals? And remember too that before the remedies is kicked off, we want to make sure that there's a mitigation of damages argument. Okay, and then we also want to argue up here that in the event that there's a conferring of a benefit, that could be an argument, and I'm just going to put a little asterisk here. It's a possible argument of a covenant. Okay. Oops, make sure I spell that right. Okay, okay, there it is. And what would that be connected to? The benefit conferred to Barn. Okay. Now underneath remedies, then we want to make sure to connect something to that. We're going to probably argue. Oh, right after incidentals here. Thank you for your patience. Quasi contract. That in the event that Sam is unsuccessful in his claim, he'd be able to recover the reasonable value of his services. Okay, so make sure to throw in a conclusion here, and that should pretty much establish all of the issues. Okay, now continuing forward though. Now, is Barn likely to prevail in its lawsuit seeking specific performance against Sam? Now let's bring up the font on this. Thank you for your patience. Okay, throwing down specific performance here. Remember, under specific performance, we have a valid contract, which is referring to the above. Okay, and the argument was, what about conditions satisfied? That's what we have also referred to the to above, that with our discussion right up here under the condition precedent. Okay, and then underneath after that, we're going to talk about inadequate legal remedies. And remember, underneath this is where we would bring up the aspect concerning the prohibition against indentured servitude. th Amendment. Okay, but there would also be an argument as well in here that we're dealing with a possible unique service. Okay, so just that would be an argument as well. Okay. Now, then mutuality. Oh, make sure mutuality of enforcement and defenses, which at this point we would be looking to latches, which I don't see that as being part of this. So we'll just it's a possible defense though, latches. Okay, and then we would also talk about I think that's it. And then now the argument could be made then, could barn require specific performance from Sam? I would have to say no on that one because the prohibition against indentured servitude, 13th Amendment, because of this being a services contract, I would say no. But make sure to walk through all of our discussion concerning specific performance. Oh, and then we want one other thing though, feasibility of enforcement. And you know what? Thank you for your patience on this one. Mutuality of obligation and feasibility of enforcement. Thank you. All right. So that pretty much takes care of the one underneath question number 3. Let's go to question number right down here. Question number 1. We'll bring this up here to the top of the page. Oh, there we go, right there. Center it. Okay. Now with all of our essay questions, let's begin with the call to question. What rights, if any, do Wendy and Sid have in the California condominium? Discuss. Answer according to California law. 2. What rights, if any, do Wendy and Bill have in the state X house? Discuss. Answer according to California law. 3. Will Hank's creditors be able to reach the assets in the trust? Discuss. Well, we don't quite know exactly yet what these rights concern, so let's read our question. 2006. While Hank and Wendy were married and living in state X, make sure to put this in married living in state X, a non-community property state. Big. Oh, I already can tell you right here what area of law we're dealing with is community property law. They purchased a house in state X and a condominium in California with money from Hank's salary. Hank took title to both the house and the condominium in his name alone. In 2008, Hank executed a will leaving whatever he might own at death to Wendy. As allowed by state X law, only one witness signed the will. In 2016, Hank and Wendy retired and moved to California. Hank conveyed the condominium to himself and to Sid, his son from a prior marriage, as joint tenants with right of survivorship, doing so as a gift to Sid. Hank then put $100,000 he obtained from an inheritance into a valid revocable trust. Make sure to point out that this is an inheritance here. Okay, let me sure. Excuse me. Thank you for your patience. Into a valid revocable trust, the income to be paid to him for life, then to Wendy for life, remainder to Sid. In 2017, as a result of a skiing injury, Hank lost all mental capacity and was on the verge of death. In accordance with Hank's prior wishes, Sid was appointed as Hank's conservator. Sid prepared a codicil to Hank's will. It sounds like we're in a crossover area here. Giving a 1/2 interest in the state X house to Hank's best friend Bill. Sid signed the codicil as conservator and had it properly witnessed. In 2018, Hank died. Sid found that Hank owned various creditors more than the value of state X house and the California condominium combined. Now, what rights, if any, do Wendy and Sid have in the California condominium? Discuss. So let's begin now by establishing that California is a community property state, okay? Let's right down here. Okay, and then come down. We want to make sure to establish what was the source of the condominium. So we want to make sure to talk about the condominium here. So the source of the condominium looks to me up here. They purchased a house in state X and a condominium in California with money from Hank's salary. So Hank's salary during the marriage would be considered community property. Absolutely. So let's call that CP here. Now, after, what happens to that condominium is what we're going to be talking about right next. Okay, Hank took title to both the house and the condominium in his name alone. Remember, title, the title presumption. Okay, now down here, in 2018, Hank executed a will leaving whatever he might own at death to Wendy. Now remember here, make sure to call to what rights, if any, do Wendy and Bill have in state X house. Make sure too that, and then number 3, what, oh, you know what? I'm getting a little ahead of myself here. I have to make sure to address each question here, so let's do that. What rights? Oh, that's interesting. Okay, let's try this again. Thank you for your patience here. Oh, all right, let's pull this back up. Okay. All right. Thank you guys for your patience here. Right here. Okay, number 1. What rights do Wendy and Sid have in the California condominium? Okay, question mark. Okay, and then come down to number 2. What rights do Bill and have in state X house? Okay, and then number 3. Well, will Hank's creditors be able to reach the assets in the trust? Okay. Okay, now, having established that, let's get right to work here, issue spotting. Now, in 2008, Hank executed a will leaving whatever he might own at death to Wendy. As allowed by state X law, only one witness signed the will. Okay, so we also want to make sure to note that up here concerning the community property thing, that we're dealing with not just community property but quasi community property. Okay, because they purchased this. But remember, well, let's see. Let me see this here. They purchased a house in state X. The state X house is the quasi community property. So thanks for your patience on that. So source. Okay, and then we come down and look at, okay, so Hank executed a will leaving whatever he might own at death to Wendy, as allowed by state X law. Only one witness was signed the will. So right here, we want to make sure to talk about valid. Okay, we've got the 2008 will. Okay. In 2016, Hank and Wendy retired and moved to California. Also adding more support to the fact that we're dealing concerning with specifically the state X house, the quasi community property. Hank and Wendy retired and moved to California. Hank conveyed the condominium to himself and to Sid. Okay, right here. The conveyance, this would be a management control situation. Okay. 2016. Okay. Up here, okay, now here we go, right here. And now, conveyed the condominium to himself and to Sid, his son, from a prior marriage, as joint tenants with right of survivorship, doing so as a gift to Sid. Okay, Hank then put $100,000 he obtained from an inheritance into a valid revocable trust. Okay, now down here, right here, we're talking about the trust. Would be separate property because it was the inheritance, the $100,000. Okay. Then, okay, let's see, right here. Okay, into a valid revocable trust, the income to be paid to him for life, then to Wendy for life, remainder to Sid. Make sure to talk about here, trust. Okay. Or, excuse me, this trust creation. There it is. Then down here, okay, 2017, as a result of a skiing injury, Hank lost all mental capacity and was on the verge of death. In accordance with Hank's prior wishes, Sid was appointed as Hank's conservator. Sid prepared a codicil to Hank's will. Okay, so it's right here. Codicil. I want to make sure to note that Sid prepared this as Hank's conservator. Okay, and then down here, okay, yeah. Now in 2018, Hank died. Okay, Sid found that Hank owed various creditors more than the value of the State X house and California condominium combined. So when we look here now at the death, right here of Hank. So 2018, death of Hank. We've got to ask ourselves here, up here, concerning the quasi-community property, that what we're dealing, okay, at the quasi-community property, the title, the property that's owned by the, okay, the owning spouse, concern the party, the spouse that owns the property upon the death, if they are the decedent, that particular property, if I remember correctly, does not pass to the surviving surviving spouse except for one half. So I want to make sure to point that out. So because Hank, now this is concerning the State X house, and I appreciate you guys hammering this out with me. I appreciate this very much. Okay, one half to Wendy, and I believe the other half then would be available to the creditors. Now, because of that being in the quasi community property, the State X house meaning. Now for the condominium though, okay, up here, remember the condominium was what up here? It was actually put in to the will, if I remember correctly. Let's see right here. He conveyed the condominium to himself and to Sid, his son, from a prior marriage as joint tenants with right of survivorship, doing so as a gift to Sid. Now Wendy, because she what Hank did was without Wendy's consent. Wendy could technically put this aside, okay, well, up to a year. But did that actually take place? See the 2016, 2018, and that's the aspect here. I don't think so. Then Hank then put $100,000. Okay, this is an additional aspect here. So we want to make sure to bring that to light under management control, that Wendy's consent was needed. And right, I think this is basically where the condominium, according to what I understand, the condominium at that point, trying to think about this now. I don't think it's available. I'm gonna put this may not be available. Okay, and I appreciate you guys for your patience in this. This crossover is definitely a challenging one for me at the present moment. So I appreciate you staying with me on this. We worked through it as much as I possibly can. I and so okay. I want to put a shout out to Chest Cruncher TV. Keep chest crunching, Chest Cruncher. I also want to put a shout out to my Amazon Kindle book, Battling the Big Bad Baby Bar, Essay Basics. Thank you for tuning in, and God bless.